This was scheduled for a ruling on the motions to dismiss. I had already concluded I would probably set that over to find out what Judge Markson did in his case. You may recall we scheduled this one so we'd have the benefit of Judge Markson's decision before we went full bore on this one. But then yesterday I got a motion from the state to essentially require service on the Joint Committee of for review of administrative rules. Is everybody aware of that? Did everybody get one? Okay. My thought on that, I mean, I think it's...
I didn't get one. Higgins didn't get one. So.
Okay. You going to give him one?
I can give him one. I don't have it with me. Mr. Higgins hasn't technically filed a motion. That is why he wasn't served.
Oh, okay. Mr. Higgins isn't moving to challenge the rules? Isn't challenging the rules?
Not at this point. I mean.
Okay, so he's not challenging the, like everybody else, the constitutionality of the prosecution, right?
Correct.
Okay. So we'll need to figure out what we do with Mr. Higgins. Yeah, we're going to talk about Mr. Higgins after we do with everybody else. So you can stick around, but we'll talk about everybody else first. Okay, everybody else got it. You know, when you mentioned it, I thought, yeah, that sounds right. You do. My recollection is you had to serve them when you challenged the rule. Although I think it's still debatable because this is a past tense rule. I mean, let's say you had a case where at issue was the validity of some rule that was in existence in 1947. Would you really have to serve the Joint Committee on Review of Administrative Rules to have that determined? This rule doesn't exist anymore, right?
The emergency rules have lapsed. That's correct, Your Honor.
Right. But it's debatable. So, I mean, maybe you do still have to serve them. I don't know. What I thought we should do is similar to what we should do probably in this circumstance is give the defendants who are challenging the constitutionality of this rule on its face, or prosecution on its face, I think it's a rule, to go ahead and effect service or not. If you effect service, then that issue will be moved. And then the Joint Committee on Review of Administrative Rules can decide to intervene or not. I assume the Attorney General wouldn't represent them. They'd probably have to get Mike Professor Friedrich. But I'm guessing that would be how that would work. If they didn't get served, if you didn't serve them, then we'd have an issue as to whether or not we'd have to disallow the defense for lack of service on the Joint Committee. But maybe you'll decide to serve them and just obviate that issue. So that was kind of my proposal, is to give them time to effect service. Since they're not, the normal 227.40 case, the person challenging the rule is the petitioner, not the defendant. And then we would probably do the same thing. We'd say, here's a deadline for effecting service. If you don't do it, we're either going to dismiss your case or rule that it's not applicable. In the case of defendants, it's a little different because you're defending the state's prosecution. So I would propose saying, I don't know, 40 days sound okay? 40 days to effect service. And then they would normally have, they're not exactly defendants, respondents, I suppose, on this issue. They're respondents. In a normal 227.40 case, I couldn't tell you what time they have to respond. It's not coming to me off the top of my head. Ordinarily, the state, though, has 45 days to respond to a civil complaint, I think is the rule. But anyway, it might make sense to give them 45 days to see if they want to appear and if they do to get counsel, because they're not going to have this. They probably won't have the Attorney General, or maybe they will. Does that sound okay? 40, 45?
That sounds okay to the state, Your Honor.
Does that sound okay to you, defendants?
Yes, sir.
So then what we needed to do is, I'd say just schedule another, continue whatever we have today, continued proceeding till about roughly 90 days from now. Now, sometimes in cases you think, well, there's some urgency, and 90 days is a long time. In some cases you think, nah, it isn't really that's something I wanted to talk to you about. I don't have any sense of urgency on this. Is that fair?
That's fair, Your Honor.
Okay. Defendants too, you guys are, no one's looking at prison time or anything, so it's kind of a low-key kind of controversy, as things, as hyper-political cases go. It's kind of on the low end of the intensity. I was thinking about that when I was just thinking about the case generally. You know, there have been, in recent history, and of course Pete Seeger is an example, where there's been quite a bit of intensity surrounding the expressive activities. You know, where there's real polarization. You know, civil rights, anti-war, where really people felt very, very strongly about what was going on both sides. In contrast, the good thing I like about this case is I sort of don't have that sense that people are really strongly, you know, entrenched, that nobody wants to beat up somebody because they have the opposite view. So that's good. Oh, you want to beat up somebody?
Not literally. I would just like to express on behalf of my understanding of my client's position, Nadine Wright, is that the feeling is equally as deep, but there is a determination to remain civil and to address things truthfully and productively, to be generous with the time, and because, as the court suggests, there's a less sense of urgency. But I don't think that negates or is in opposition to the depth of intensity of feeling.
All right. My experience as a human being, as a judge, is that actually, to be honest, people are able to behave more civilly the less intensely they feel. And in fact, the greater the intensity of feeling, the more difficult it is for people to master that. To the extent all of you are driven by intense feelings, and you're able to control that in a civil way, I appreciate it. All right, so in terms of what I'd like to do is schedule this then just 3 months out. I assume you filed similar motions with Judge Markson, or not? Did you file the same motions with Judge Markson, or not?
I'm not representing the state in those cases, so I'm not sure. I know we are filing them and making sure that, to the extent it hasn't been filed, we're making sure they're filed in all cases.
I don't know, because I know he was, you know, going to be issuing a decision on his case, but on the cases, but that might slow it down. Off the record.
Thursday, May 1st.
Could we do it on May Day, though?
Perfect. Yes, please. Yes.
Okay, Thursday, May 1st. What time? Why don't we do it at 10 o'clock? How's that sound? May 1st at 10 o'clock? All right. Back on the record. So we're going to schedule this for continued proceedings, including, at this moment, it's scheduled for an oral ruling. We'll continue that for Thursday, May 1st at 10 o'clock in the morning. But recall that had we not had this motion from the state, and it's not bad you brought it, because if we don't have confidence, it's too bad to spend a lot of time on a case. You do want to sort of address that issue. But we'll also be addressing if anybody chooses that they don't want to serve the JCRAR, and they want to go forward on the claim they don't have to serve the JCRAR, then we could address that issue too. I'm anticipating you'll just go ahead and serve them, and then that issue will be resolved. This will give them plenty of time to be served, to get counsel, to get up to speed. All right, so that's that. It mostly resolves our case, but I do have this I do have just sort of a question generally. And again, this goes to sort of the intensity of feeling issue. Just a general sense for those of us that don't visit the Capitol or see any of this happening other than on TV. My understanding is that since September, there's been a settlement in the federal case. I was provided a copy of the settlement by the state at my request. And that there is no ongoing enforcement action. Is that correct? Or law enforcement, no arrests or anything like that?
My understanding is that people in the Capitol have been complying with the terms of the settlement and the new rules and system in place.
Okay, and so what does that mean, complying with the new rules?
I'm not an expert on the new rules. Certainly the settlement describes them. I believe there's new emergency rules that have recently been published, but it's a system that allows both a permitting system as well as a noticing system, creates a floor for 12, and gives certain preferences based on which terms of notification you give the Department of Administration with regards to your event.
Okay. So in your view, there isn't any ongoing law breaking?
Again, I'm not familiar with the day-to-day operations, but my understanding is that there has not been many tickets or arrests issued subsequent to the settlement.
Allegations of law breaking.
Now, let me ask you this, because it did occur to me thinking about these cases. Since we don't have the rule anymore that is being enforced, and since there really isn't any ongoing alleged law breaking, or much of it, there aren't many arrests or anything like that. My understanding, there are about 400 of these cases pending in Dane County Circuit Court.
I think that's somewhat accurate. I'm not sure of the exact number, but it is several hundred.
Well, I had this question. You know, the courts are open to everybody, and that certainly includes the state. The state wants to be heard, we'll hear them all anytime. But people who have the authority to direct resources in prosecution, who have the authority to decide what cases the state's going to be involved in, I think have some obligation to exercise that authority using good judgment and some consideration of what the resource costs and benefits are. I've yet to sort of get a sense in these cases, and admittedly we haven't gone very far in these cases, other than the one we tried, as to really what the state's purpose is in pursuing 400 forfeiture cases regarding events that occurred last summer under a legal system that's no longer in place, and where the arrests aren't continuing. Are you with me, Mr. Brissett?
I understand your question, yes.
So I really think it would be beneficial for your office to formally evaluate the costs and benefits of pursuing these 400 cases in Dane County Circuit Court. As to what exact, what the state's objective is, which would be the benefit, and what the costs are in real terms. Because I mentioned Michael Besson Friedrich. I mean, if the JCRAR does appear in these cases and you don't represent them, then there's going to be another resource cost. But I think it would be desirable for your office to do a good faith analysis of what the costs and benefits of these 400 cases are under these circumstances. So that to the extent you're missing something, you don't. So that if you can make an informed decision, and then you can apprise the court of what your evaluation was. And I mean, for example, got all these defendants, they have time. They have lawyers, that's a cost. We've got a bailiff. Sometimes we'll have more than one bailiff. We've got the court staff. We've got 2 assistant attorney generals. We have witnesses. All of that are significant costs. And if we're doing it 400 times to accomplish what? Well, that's what I'd like you to be able to apprise me of. And so I am asking you by the time we next meet to be able to, and actually what I'd say is 30 days prior to the time we next meet, if you could submit that analysis. You follow me, Mr. Brissett?
I do, Your Honor.
All right, I appreciate it. That would even apply in Mr. Gonzalez's case. Because even though he's not challenging the constitutionality, it's still, and juror costs. He wants us to have a jury on this case, I assume, right?
Yeah.
I'm sorry, you say yes, not
Yes,
yeah.
Your Honor.
All right, thank you.
And it might be.
Yeah, we're not, you've already spoken out of turn, so just keep in mind, we're in court, I'm the judge, you're the lawyer. And it's yes, Your Honor, right?
Yes, Your Honor.
So, yeah, jurors, we're gonna what? I mean, I suppose the people that are making the decisions don't care too much about voters in Dane County. But, the courts do. It's an imposition to somebody to bring people in and make them sit on a jury. So, I'd like you to evaluate those costs.
I will get back to the court with that information, Your Honor.
All right, thank you. Anything else on the cases excluding Mr. Higgins' case?
Thank you, Mayor.
Anybody else?
Thank you.
All right, so then, we'll see you all on May 1st.